Okay, so good evening, guys. Hope I am audible. Today we are going to deal with the legal marathon. So, legal section is one of the most scoring section. Move to the second slide, Kanish. So first, let's discuss some strategy regarding this section, and then directly we will be moving towards the question. First is the for the legal section, you have a number of sources to read and practice. The most important thing in the legal section is the more you do the practice, the better you will be getting your accuracy in the section. So always refer to the different articles or related to legal news from the live law, bar and bench, career launcher, or whatever legal sources you are getting from the different websites. You can read them. Make sure you are reading and understanding, and you are in touch with every current legal happening, along with the different static legal knowledge like tort, contract, crime. You should be in a position to understand this thing when the passages come on the D-Day. One of the most important thing for the legal section is that you have to stick to the passage, that is whatever is in the passage. Even if in the passage it is given that something which is given in the passage which you know is not true, but then also you have to assume that it is true. You cannot apply your own mind there and states that this is means my knowledge is more than what is given in the passage. Whatever is in the passage, you have to stick it to that. And the next is the score. It is one of the most scoring section, but don't assume that you will be getting a score of out of, if there are 35 question, you will be getting 32, 33 now in the month of December. That you will be getting in the month of April or May, not now definitely, but it is a very scoring section. You can easily score 30 to 33 out of 35 in your Clat examination. For that you should be in touch with both. You should neither leave the static legal nor the current legal, because Clat is very unpredictable. So it is suggested to you to be in touch with both the static and current legal, so that whichever type of passages come in the final Clat on the D-Day, you are in a position to solve them. That is just a small strategy, because it is a marathon, so we'll be practicing lots of questions. And remember, this legal section requires a lot of practice. You cannot assume that if you practice for 2 months and you will be getting a good score. You have to practice it. A lot of questions from everywhere. Lots of questions are in the drive. Give the different test, sectional test and mocks, and then you will be done with the legal section. So without wasting time, let's start with the first passage. Before moving to that, I want to ask you that whether you want to solve all the 5 questions and then I will be helping you out, or whether we will be moving one by one. Just write in the chat box that whether you will be solving all the 5 questions and then we will be doing the passage, or you want to move one by one. Just write it in the chat box. Okay. Okay, one by one. Okay. So let's start with the first passage. The first passage, you have even the PDF in the group. You can take it from there also. The first passage is related to the Dowry Prohibition Act that is prevalent in India. So start reading the passage. Once you're done with the reading of the passage, let me know in the chat box. हम्म, ठीक। नहीं अभी नहीं आया। ठीक है, ठीक है, ठीक। अच्छा ठीक है। हम्म। सानवी, जब नीचे का गेट खोल दो तो सर आएंगे अभी। Okay, so I guess it must have been done till now. So basically, this passage talks about the Dowry Prohibition Act, which is prevalent in our country. That is regarding that if within the 7 year of the marriage, if any burn or bodily injury is caused to the woman and she dies, then it will be a dowry act, or it will be considered that the cruelty has been done by the family member or by the husband other than the normal circumstances. Okay, this is very important, that other than the normal circumstances, अगर normal circumstances में अगर उसका death होता है तो in that case the husband or the family would not be liable. Otherwise अगर किसी any type of burn or bodily injury अगर दिखता है within 7 years of the marriage and it is shown that soon before her death she was subjected to cruelty or harassment by her husband, then this will be considered as a dowry debt. Now dowry, which is what is dowry, that is very important. It is something, any security, property or anything which has been given in consideration for the marriage. Okay, this is a very important thing, that whatever property or whatever product is being given, it is given in consideration for the marriage. So accordingly you have to solve the question, and then it state that this line is very important, that the court has further defined dowry in the sense of expression contemplated by Dowry Prohibition Act in a demand for property or valuable security having an inextricable nexus with the marriage. That is a consideration from the side of the bride's parent or the relative to the groom or his parents or guardian. So this is all about the Dowry Act, that you have to understand from this passage. It is a very small passage, that what is dowry, what is the punishment that one will be getting, what is the time period within which the death has to be caused, and this all thing only you have to know. Now let's directly move to the question. Yeah. Okay, so this is a very simple question, that before the marriage the groom parents insisted on the girl's parent to buy the groom a car, and then the bride's parent promised to do the same, but even after the marriage they could not give the car. Due to this the groom was abused and then she was sent back to the matrimonial house. Now she died due to the collapse of the house caused by an earthquake. Now can the in-laws of the girls be held liable for causing dowry? So just move a slide back. In the last slide we have seen that it is written very clearly that it is caused by any burns or bodily injury other than under normal circumstances. Now in this question it is very clearly stated in option number B. Yeah, Kanish, you can move to the question. It is clearly stated in the, yeah, in the option number B that C has died in the normal circumstances because of the collapse of the house during the earthquake. So it was a very easy question. Now let's move to the second question. Okay, so the second question, move to the second question. Here it talks that it was the flat so that both of them can reside in it. Nowhere it is mentioned in the facts of the question that the flat was in consideration of the marriage. So option number A is correct, that no, as the property was not bought by one party to the marriage for another party. The property, the valuable securities that was bought, it was not in consideration of the marriage. So option number A will be correct. B is no, no, as the bride parent bought the, it is already in incomplete option. C, it is yes, so definitely it will not be considered because the property was not given in consideration of the marriage. So the correct answer is option number A. Now let's move to the third question. Okay, so in this question what had happened that they has demanded a 10 lakh rupees as the dowry, but they had only given 5 lakh rupee, after which the marriage was done. But after the marriage they kept on taunting the bride regarding the small amount of dowry, and they deprived her of the food and confined her to the home, as a result of which she died because of the malnutrition and disease. So it is clearly very easy question also, this one. So the correct answer is A, that yes, as he died after being harassed in connection to the demand for dowry. Now, why option D will not be the correct answer? Can anyone state it?
बिकॉज मैरिज का कितने इयर्स हुए ये क्वेश्चन में कहीं पे भी मेंशन ही नहीं है।
भैया
Okay.
बॉडी इंजरीज भी मेंशन नहीं है।
Yeah, definitely. Both of your three of you are correct. Nowhere it is mentioned about the bodily injury. There, nowhere it is mentioned about the how much time the marriage has completed. So let's move to the fourth question. Kanish, you can do one thing, that stop sharing and hide one. No, you can put it little bit down. Yep. Okay. So this is the same, just like question number one. Uh, Same like question number one, that they had asked the bride parent to buy her some ornament to wear it in the function at her marital home. Okay, so here what happened? This is not regarding the marriage. No, this is not regarding the marriage, that for the marriage you give it, or because we have married your daughter with our son, you have to give the ornaments. Just for the for wearing in the function, they had asked that you can buy the some ornament for the bride. So the correct answer is C, because as the demand for ornament did not have inextricable nexus with the marriage. Now with option number B, it could be have been correct if it has been mentioned in the facts that on the occasion of Diwali, the groom parents asked the bride parent that because your daughter had been married to our son, or in consideration of the marriage that has been performed already, you have to give the ornaments, then option number B would be the correct answer. But in this case, it is for the occasion is different, there is no nexus with the marriage, as a result of which option number C will be the correct answer.
भैया अगर सेम 7 ईयर बाद पूछते वो तो
फिर से कनिष्ठ फोन नंबर।
अगर आपने अभी जो केस बताया वो सेम केस अगर वो 7 ईयर्स के बाद पूछते तो
हाँ, in that case it would not qualify as dowry. Okay, Kanish. Always remember to choose the most appropriate answer, guys. So this is something hierarchy that she has got it from her mother and then grandmother, and it's then she has given it to her mother-in-law. Now option B could have been the correct answer if option D would not had been there. But option D con consider both the thing, the property one also and the consideration of the marriage. And as it was mentioned in the passage that the property should be given in view of the consideration of the marriage, option D is the most correct option. Although option B is not a incorrect one, but option D is the most correct option. So we will go with option D because it is considering even the property and even the consideration for the marriage on which the passage is based. So this was the first passage regarding the Dowry Prohibition Act. Now what we have seen in Clat 2021, just a minute Kanish. What we have seen in Clat 2021, most of the passage were static GK. So basically in this marathon we are taking in all the static passages only. In the next marathon we will be taking the current legal passages. So now let's move to the next passages, which is based on the Preventive Detention Act. So start reading. चलो छात्र कपड़ा लेके आएंगे। हाँ धीरे धीरे आओ, धीरे धीरे। धीरे धीरे, धीरे धीरे, धीरे धीरे। Okay, can I move to the next slide? Okay, previous slide. One more time. Okay, so this passage is talking about the Preventive Detention Act and the which is in the Jammu Kashmir, which talks about that इसमें to maintain the law and order and the public order situation without informing anyone that why are you being put under preventive detention, आपको अंदर कर दिया जाएगा 2 साल के लिए. There will be no trial with you, you will not be informed on what ground you have been put under the Public Safety Act. This all thing has been mentioned under this act. And similarly for the other state, we have the National Security Act. Okay, so next slide, Ganesh. And then it talks about Article 22 of the Indian Constitution, which state that uh, every person has to be informed on what ground he has been arrested, or he has to be presented before the magistrate before 24 hour, means within 24 hours. But 22 clause 3 is states that nothing in clause 1 and 2 shall apply to any person who for the time being in an enemy alien, or b to any person who is arrested or detained under the preventive detention. This is all about the passage. Now let's move to the first question. Okay, so it is a very simple question that he has been put under the Public Security Act, but there was no presentation to the court, and habeas corpus was filed in behind be on behalf of him, but no such thing will happen because his appeal would be rejected as his case was registered under the Public Security Act. That is option number A. Now, it caters under the protection of the fundamental right. 1B will not be taken into consideration because in this case it is Article 22 clause 3. Now his appeal would be rejected as he is a timber merchant. It is a very useless option, and his appeal would be accepted as the government is at fault and has to be treated under Article 22 clause 2. It will also be not taken into consideration. So the correct answer is A. Now next. Okay, so it is the same that it was very communal. There was an influence of the political party who wanted to create a rift in the mind of the people, and then the National Security Act was imposed. So definitely it can be imposed, as it was mentioned in the first slide of this passage, that to maintain the law and order for the security of the country, it can be used. Now let's to beat it. Now the correct. Now let's move to option number A, that no, as every person has freedom of speech and expression. There is nowhere mentioned in the passage about the freedom of speech and expression as a fundamental right. So we all know that freedom of speech and expression is a fundamental right, but we cannot use it here. This is the point number 3 of the strategy, that you have to stick to the passage. Now, option number C. This is a complete violation of the person's fundamental right, and right to protest is the same thing, that it is not mentioned in the passage. Yes, the detention was not legal and the person belongs to a political party. It is a useless option. So the correct answer is option number B. Let's move to the next question. Okay, so Ganesh, first move to the passage once. Okay, so see guys, those who have marked option number D, can anyone tell me why D? And for A, can anyone tell me option number why A?
There's nowhere mention of the freedom of movement in the passage.
Okay, for option number A.
Bhaiya, it is mentioned in the passage that the person who is detained under the PSA has limited rights. It also includes the right of movement. So, option A.
Okay, anybody have any different opinion? Okay, so for this, the correct answer is A. That is, it could be justified when there is national threat to the state, as the freedom of movement and all mobility rights could be snatched under the Public Security Act. Guys, it has been mentioned as stated by Monica that limited right can be there, and the same thing is being talked in A option, that the freedom of movement and mobility rights could be snatched under the Public Security Act. So option number A would be the correct answer. B, it could not be justified, so we will not be taking it into consideration. C, it could not be justified because of the right to freedom and all, it is talking about privacy, so that is useless option. Now why not D and why A? Because it is very clearly mentioned that limited rights, not this limited right includes the freedom of movement, and as it is mentioned, all mobility rights can be snatched, could be snatched. So we will go with option number A. It was a very good question. Next. Okay, so you guys can also make blind option also, you can select. No, there is no such worry. Okay, why option number D will be the correct answer?
क्योंकि उसमें मेंशनड है कि वो एप्लीकेबल ही नहीं होगा अगर वो पीएसए के अंदर या किसी भी प्रिवेंटिव डिटेंशन लॉ के अंदर डिटेन होता है तो।
Yeah, and that could be have, अगर ये ABC या ABC में अगर if this would have been mentioned, then it would be correct, but this is not mentioned. It is talking about the public interest and article 22 clause 1. This is correct, definitely this is correct, this is not right, this is not wrong, but not for option question number 4. Question number 4 के लिए option number C नहीं बैठता है, because it is because of the Public Security Act that 2021 clause is not applicable, 2022 is not applicable under the 2022 clause 3. Now let's move to question number 5. ओके, गेटिंग ऑल टाइप ऑफ ऑप्शन। बी भी कोई बता दो अगर बी भी हो सकता है शायद तो। ओके, सो वन बाय वन जिसने जो मार्क किया है अपना अपना एक्सप्लेनेशन यू कैन गिव।
Bhaiya, I have marked A because according to the passage, the preventive detention is legal in case there is a threat to public safety. And here, a threat is imposed on public safety. So I think he is correct.
ओके नेक्स्ट।
Bhaiya, C is same as A but at broad level because college is not enough.
ओके, एनीवन एल्स?
According to me, it is not correct by the officials.
So the correct answer will be option number, yep. So the correct answer will be option number B, because this was not a situation that would lead to an emergency in the state and would create compromise to the safety of the people. It was just a college election. This is not a very big thing, and most probably don't compare it with here. Just take it to the Supreme Court and the Delhi High Court bail given granted to various JNU students related from Sarjil Imam to Kanhaiya Kumar and all. If that would have been the situation, then this would have been, they would also been have been booked under the NSA Act. But all of them have been given the bail. So this it was just a college election, and it would not create such a rift in the state. It would not create an emergency situation in the state. Always understand from the passage it was given that the public security would be in a compromising position. But this was just a college election. It was not a much a big deal. So the correct answer will be B, 5B. Now we move to the next passages, which is talking about culpable homicide and culpable homicide amounting to murder. That is section 299 and section 300 of the Indian Penal Code. Start reading. Okay, so this is one of the very important difference whether you are going to become a lawyer, whether you are going to become a judge, or whether you are going to study in the law college. Understanding the difference between culpable homicide and culpable homicide amounting to murder, that is section 299 and 300. So let's read both of the provision. That the purview of section 299 of the Indian Penal Code states that an act done with the intention of causing death or causing such bodily injury which is likely to cause death, or having the knowledge that he can likely by his act cause death, that is done, means there is an intention of causing death, and the person who is doing that act, he knows that by his act there is a likeliness that death would be caused. Move to 300. Culpable homicide is murder if the act done with the intention of causing death, or if it is done with the intention of causing such bodily injury as is likely to cause the death of the person, or if the inflicted bodily injury is sufficient enough. This is very important. Sufficient enough in the ordinary course of nature to cause death, or if there is knowledge involved that the act done is so fatal that in all probability it will cause death. So this is the only and only different, guys. Remember it for your whole life from now onward. In your law school you will be facing the same thing, in your practice as a judiciary, in a judge also. The difference is that in 299 there is a word likely. So the act that has been done by the accused person was that it would be likely that the death would be caused. But under section 300 it is of such a nature that the act was sufficient enough that it would cause death. This is the only difference between 299 and 300, likely and sufficient enough. So let's move to the first question. Apply the logic of silogs. Okay, if your silogs is good, then only you will be able to solve this question. Apply the logic of silogs that you have done, that which will be the outer circle and which will be the inner circle, then you will be able to solve the question. Okay, so getting very less response states that. Okay, the correct answer is option number D. The correct answer is option number D. Take the logic of silogs, guys. Take culpable homicide at the outer circle and murder in the inner circle. So it is very clearly stated that all murder are culpable homicide with intention. So culpable homicide is not murder, but murder is definitely culpable homicide. So that means the culpable homicide is the outer circle and the murder is the smaller circle. So the correct answer will be option number D, that is culpable homicide is the genus and murder is the species. Is it clear? I hope. Yeah.
Bhaiya, please explain option B. I'm
Intention,
not able to eliminate it.
yeah, intention to cause culpable homicide amounts to murder. So why, anyone, why B will not be the correct answer? Those who have eliminated B, you must have known the reason that why B will not be the correct option. Okay, so I am telling you, see, the question was of that of Monica. See, it is written very clearly stated that all murder are culpable homicide with intention. So intention to cause culpable homicide amount to murder is the same thing. It is not a derivation, Monica. You have to take out the derivation. What is written in the passage, in the facts, it is same thing is mentioned in the option, that intention to cause culpable homicide amounts to murder. You are not getting any derivation. The derivation is that the culpable homicide is the genus, that is the outer circle, and every murder come under the culpable homicide, that is your the inner circle. So the culpable homicide is the genus and murder is the species. Okay, and one more, something I saw in the chat. Explain option C. So option C will not be the answer, Ankit, because murder is not the outer circle. Every murder does not mean culpable homicide, but every culpable homicide means murder. Okay, in the culpable homicide, see, I am telling you, culpable homicide में क्या होता है? According to the passage, move to the first slide, Kanish. According to the definition of culpable homicide, what is given in here, that culpable homicide is intention to cause death. The same thing is in the murder for section 300. इसमें भी क्या होता है? इंटेंशन होता है. बट कल्पेबल होमिसाइड तो लाइकली है, पर मर्डर में क्या है? सफिशियंट है. तो लाइकली तो ऑटोमेटिक, जो सफिशियंट इनफ जो है वो किस में चल जा रहा है? अंदर चल जा रहा है, और लाइकली तो वो उसको कवर कर ले रहा है ना. कल्पेबल होमिसाइड का लाइकली जो है वो उसका सफिशियंट को क्या कर रहा है? मर्डर का सफिशियंट को अपने अंदर कवर कर ले रहा है. इसलिए कल्पेबल होमिसाइड इज द आउटर सर्कल एंड मर्डर इज द इनर सर्कल. ओके, okay, next question, Kanesh. Okay, so question number 2, the correct answer is C, because see, why not B? Because Raghu is guilty of culpable homicide, because the probability of causing death by a dog is not that absolute, but it is very clearly mentioned, guys, in the facts, that the dog was having the capacity to rip apart a human if unleashed. अगर उसको खुला छोड़ दिया जाएगा तो even it can tear the body of a human. So definitely the correct answer will be option number C, that is, so the correct answer is 2C, that he is guilty of murder under section 300. Okay, so the correct answer is C, because it is very clearly mentioned in the facts that the dog has the capacity to rip apart a human. So because of that particular line, that it is having the capacity to rip apart a human, option number B will not fit there, because option number B second part state that since probability of causing death by a dog is not that absolute, but it was mentioned in the facts that it is having the capacity to rip apart a human. So there was, the act was cause, it was sufficient enough, there was intention, so it is section 300 of the IPC. Okay, Ganesh, next.
Excuse me, Bhaiya.
Yep.
Bhaiya, I got disconnected. What is the answer for question number 2?
Okay. Ganesh, move to the slide. The correct answer is 2C. He is guilty of murder under section 300 because there was intention and the dog was sufficient enough to cause the death of the human. So the correct answer was C.
Okay, Bhaiya, thank you.
Yep, Ganesh. Okay. So we have got option number A, B, C और D तो नहीं हो सकता क्योंकि no offense होगा नहीं. So first let's start with option number C. Why C will be the correct answer? Whoever has marked C.
Because Shweta was preparing for the murder of Binu, and therefore A option should be not be there because वो अपना बेटे का नहीं करना चाह रही थी, and प्रेपरेशन अलोन ऐसा नहीं है, मतलब प्रेपरेशन नहीं पूरा एग्जीक्यूट ही हुआ है, वो उसने किसी ने खा ही लिया है, तो प्रेपरेशन बस नहीं की, इसलिए बी नहीं होगा, सी होगा, बिकॉज
Okay.
उसका इंटेंशन नहीं था अपने बेटे को देने का और बी को देने का.
Okay. So, but according to culpable homicide, not much debate we will be doing. I'm telling you, Priyamvada, C will not be the correct answer because culpable homicide there should be an intention, but there was no intention to kill to the son of.
Shweta.
herself.
Okay, Sweta. So those who have marked B, why will B will be the correct answer?
Because it clearly mentioned that she wishes to give it to Binu. So it was just a preparation.
Definitely, the correct answer is B because it was just a preparation. She kept the poison food until and unless the execution is done with the person on whom it is being intended. It is just a preparation. Even if you buy even if you buy a pistol, keep it in your pocket, went to the house of Utsav, nothing till then. The moment you take out the pistol and load it on the head of Utsav, that time the execution will be done. So the correct answer is 3B. Next question, Kanesh.
But Bhaiya, won't she be liable for the death of her son?
Ankit, you asked me something, I guess.
Bhaiya, Sweta will be liable for the death of her son, isn't it?
No, why she will be liable?
Because she intentionally put the
Oh, no,
poison
no,
in the
no, no.
halwa.
She intended to kill Binu. She intended to kill Binu. And unknown to Shweta, her only son ate that halwa. There was no intention in Shweta to give it to his son, to murder his son. There was no intention to murder his son. Her intention was that of for Binu, but nothing happened to Binu. His son ate it, so there was so she will not be liable. Okay.
Okay, भैया.
Okay, so this is a very direct question. The correct answer is A. Intentionally give the sword cut or club wound, and it is mentioned in the facts that it was sufficient. So the correct answer is A. In the ordinary course of nature, it was sufficient. So the correct answer is A. Yep, 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 Priyamvada. Nowhere in the Indian Penal Code there is murder. It is everywhere culpable homicide amounting to murder, and for it the punishment is in section 302. 300 is talking about murder, which we generally tells that murder, that is culpable homicide amounting to murder, and then we have 302 which talks about the punishment for the murder. Okay, yeah, Kanish. Okay, so this was a good question. The correct answer is option number B. Let's start with option number A. Amar is guilty since he knew the gas could kill millions and thus should never have made it. Useless option. C. Amar is not guilty since he did not have the intention nor was he involved in the killing of the millions of the people. Guys, he knew that his brother was in the terrorist organization. He gave his he gave the gas which was sufficient enough to kill million of people if it would unleashed, and as already marked by Kanish Bhaiya. Now, Amar is not guilty since he had no way of knowing what Prem would do with the gas. Definitely, he was knowing it. There was knowledge, guys. In the passage, it was clearly mentioned that there should be knowledge of the thing. And the gas was sufficient to cause the death of the millions of people, as marked by Kanish Bhaiya. You can see that. which can kill millions of people, terrorist organization, this all thing you know, and there was knowledge. So the correct answer is B, that Amar is guilty because he knew his brother was part of the terrorist group and thus could use the gas to kill people. So there was knowledge, there was intention, and there was sufficient. Okay, next.
Bhaiya, that intention is not mentioned in the question.
Move to the slide, Kanishk. Kanishk, move to the last slide, fifth number question. Guys, am I audible?
Yeah, you are.
Aryan, is the slide
Yeah, yeah,
visible?
yeah.
Question number 5.
Yeah. Okay, okay.
Wait.
So, those who have marked B, explain why B will be the correct answer.
Because in the question it is mentioned that his brother Prem is a member of a terrorist organization and is thus is a cause of some acrimony. मतलब अमर को ये पता है कि इसका भाई terrorist organization में है और ये
Very good.
उनकी
Okay,
dispute का
okay,
कारण है.
okay. Very good. So, guys, see the line that this is a cause of some acrimony between Amar and Prem, and that's the result of which intentionally he has given the gas to his brother because he know that he is a terrorist organization, he's part of a terrorist organization. He will be using the gas, as a result of which million of people will be killed, and definitely then his brother will be in jail. So there was intention, Monica. Okay.
Yes, Bhaiya.
Okay. Yes. Next slide. Ganesh, the slide is not moving. Yeah, it is done now. So the correct answer is A. Yep. It is mentions the X intending to kill A. Now why not C? Because he did not intended to kill B and C. Guys, the moment he is throwing something in the public gathering, definitely he has the knowledge that the people are present there. He is having the knowledge and the throwing of the bomb is sufficient enough that it would cause the death of B and C. So he will be liable for the same. However, A escaped and suffered only minor injury, but he is prosecuted for the murder of B and C. He is liable because throwing it at a public gathering, he was having the knowledge, and definitely the gas is sufficient enough. Now, the next passage is very interesting. That is on section 375 of the Indian Penal Code. Okay, Kanish, move to the next slide. Is it done, guys?
No, bhaiya.
Okay. Today Arunab is not responding. Okay, no issue. Move to the next slide, Kanishk. So it is a little big passage.
Yeah. Okay, so move to the first slide, Kanishk.
So this passage is talking about the rape, one of the most known thing to everyone, where it talks about the distinction that the honorable court has made between the consensual sex and non-consensual sex. It is very clearly stated that the consent should be free. There should be no fraud. It has been talked about this, and then they have talked about the on the lieu of the marriage, that where the sex and all part is done on the lieu that the boyfriend will marry to the girl. On this also, the Supreme Court had made certain recommendation that at what stage what will be considered. So this passage is about that only, that when the sexual act is done with the consent of the woman or the girl, and when it is done without the consent, and that consent should not be obtained by fraud. And you are students of Lighting Dream, you must be knowing what is fraud and what is all we have done already in the taught classes. So that is all about the passage. They have talked living together, and nothing much is there. The passage is just lengthy, not much has been discussed. Now directly we will move to the question number 1. Okay, very good. So the correct answer is option number A, that because the sexual intercourse was without her consent, there was the okay. Very good. So the correct answer is option number A, that the sexual intercourse was without her consent, as it threatened to do, and as it was mentioned in the first slide of the passage, that the consent should be free, it should not be under the threat or coercion. And here the police officer has used his power. So the correct answer is option number A. Next question. Very good. The so they were having the sexual intercourse all the time, but they were just knowing each other. They were just in a relationship. They were not a married couple. So any time the sexual intercourse without the consent would amount to rape. So the correct answer is C, because it was rape. It was rape as it was without her consent, and previous consent does not matter. This is not a married life that there is, you have the marital rape laws under exception 2, because you are just in a relationship. Every time you are doing the sexual intercourse, very good, but once you are doing it without the consent, it would be amounting to rape. Now question number 3. Okay. So the consent was given to for the surgical operation to which he consented, and under the pretense of performing it, he had sexual intercourse with the girl. The correct answer is option number A. That yes, the girl's consent would not excuse the accused from conviction, and it was under a mistake of fact. It was a misconception because it was for the surgical operation and not for the sexual intercourse. So the option A is the correct answer. So very good, Utsav and Arunav. This happens when you practice a lot of question. Okay. Next question. Ganesh? Yeah. Okay. Yeah. Okay. So first of all, those who have marked option number D, what is the reason?
Yeah, because as mentioned in the passage, motive is important. If the motives are malified or a false promise is made, that is a clear cut case of cheating or deception and not a case of rape.
Okay. And those who have marked option number C. Okay. No worry. Still, you have time. Those who have marked option number C. I guess it was Utsav and Arunav.
Sir, what is the answer?
I have not yet told the answer. I am asking the reason why you have marked C.
Oh, sir, because bigamy is illegal, so like you can't have a second marriage. That marriage becomes void. So then the consent is gone. So we can consider it, uh,
Like he got the consent by using deception.
yeah, fraud basically.
Okay. Priyambada madam. Anything from your side?
Agree with Monica.
Guys, deception was for the thing. Deception was for the thing that deception is done when she is telling that I will be marrying you, and as a result of which we are having the sexual intercourse. Okay. See, if the in this case the accused had told him that I would marry you in the future, just now let's have the sexual intercourse. In that case, there would be cheating or fraud would have been committed. The correct answer will be option number D, because there without the knowledge of the first marriage, or cohabitation was given on, okay, that is cohabitation was given as he was accused, that is moving away from the passage. The passage is talking that if there is a pretext of the marriage, that the couple will be marrying in the future, as a result of which they are having the sexual intercourse. So the correct answer is D. Next question. Okay, so this was a very easy question. All of you know the correct answer is B. Now we move to the next passage. That is the last passage and one of the very important crime passage. That is the difference between section 34 and 149 of the Indian Penal Code. So start the passage. Okay, Ganesh, move to the next slide. Okay, move to the passage. I was guessing there are more passage paragraph. So this is talking about the difference between section 34 and 149 of the IPC, same as it is of the section 299 and 300 of the Indian Penal Code. It would be helping you in your law college also, guys. So 34 states that there should be an active participation and there should be a prior meeting of the mind. 149 states that merely you are part of an unlawful assembly. This shows that you are having the common object of doing that particular thing. But in section 34 you have the common intention with the prior meeting of the mind, premeditated attack, as it is mentioned in the passage. So let's move to the first question. Okay, so it is very easy question. All of them will be liable as all have the same premeditated mind. That is Rahul throwing the stone, Raj is climbing inside and opening the door, Raj merely stood standing outside. Everyone is involved in it. It is a premeditated act. Let's move to the next question. So 1C. Move to the previous slide, Kanishk. Kanishk, move to the previous slide once. No, the first question. Okay, now move to the second question. So the correct answer is option number D, because the killing, the yeah, hitting on the head from the behind of the lady was an act which was in furtherance of the common intention of disrobing her. So the all of the boys will be liable, not option number B, because all of them did not have the common intention of killing her. But the common intention was not killing her, guys. Common intention was to disrobe her, and the act which was done was in furtherance of the common intention to disrobe her. So the correct answer will be D and not B. Okay, Ganesh. Next question.
Sir, it was D for Delhi.
Yep. Take care of yourself. Don't get corona. Okay, so uh, what happened? Still robbing the house, an alarm was sounded, but everyone reached the door. Everyone reached the door before the old lady could come downstairs. Guys, Rajesh hide behind the door while other escaped. जब सब कोई चले गए डिसरॉबिंग करते हुए पकड़ाने अलार्म के बाद, तो सर आपको रुक के वहां पे क्या करना था? आपका तो आपका जो कॉमन इंटेंशन था डिसरॉबिंग का वो तो खत्म हो गया. नाउ यू हाइड देयर, you hide behind the door and then you stab the old lady, as a result of which the correct answer will be D. Only Rajesh is liable because he had the individual intention to stab her. बाकी कॉमन इंटेंशन था चोरी करना. वो जब चोरी कर रहे थे तब तक अलार्म बज के वो गेट के बाहर चले गए. सो द करेक्ट आंसर इज डी. नेक्स्ट क्वेश्चन कनिष्क. Okay, so this time when the Jamindar goons went to visit Lajaram, they together beat him harshly. So there was a active participation and there was the prior meeting of the mind. So the correct answer is option number D, because there was a prior meeting of the mind. So the correct answer is D. Very good. Most of you have, all of you have given the correct answer. Next question, Kanish. Okay, so what will be the correct answer? Apart from C, you have given all the answer. Those who have marked D, why D will be the correct answer? Okay, so C बचा था, C भी आ गया. Okay, why D, Utsav?
Because they all formed the mob to hurt them, right? So they all had the common intention.
Pardon,
So they
pardon.
all should be held liable.
Can you repeat?
because they all had the common intention to hurt them, and they had formed the mob.
Yeah, very good. So they surrounded them, and a mob, okay, and a mob armed with stick and stone encircled the oldies. Without any verbal exchange, one by one, all the youngies started pelting stone. So their active participation in the mob brings them under section 149, because the moment you stand in a unlawful assembly, you become a part of section 149 apart from section 34. So the correct answer is option number D. So 5 passages we have done. With that, we come to the end of the marathon session. Thanks guys for joining.
Thanks to you too